docks and stuff that are put there.
That's personal property.
Justin.
That's my understanding. The only thing that we have in zoning ordinance relating to docks, if you will, are boathouses, which we've had before this body.
But FYI, we are writing an ordinance with regard to those right now.
Say, Justin, what might clarify things is define real property compared to personal property. That'll do real estate 101.
Sure. So real property is the land itself. Real property also includes buildings, structures thereon, and it also includes improvements that are erected. Trees, for instance, can be viewed as real property. What's personal property is something that can be essentially taken with you. Now, this is very 101, but it's things that are not of a building or structure, but are rather like a car, a boat lifts.
Would you say things that aren't permanently attached?
That's correct.
Okay.
That is exactly correct. In fact, that's why they call, they use the word attachments in a lot of real estate contracts to describe what's going with the land.
Thank you.
I thought that would clarify if you had an awning, Dennis, that's attached to the house, that becomes real property.
I think so.
Right.
Or a ceiling fan or.
Speaker, outdoor lights.
Yeah, anything that's permanently attached.
Any other discussion? Any other questions?
But Larry can come
May
back.
I ask a question?
Larry could come back and appeal, or not appeal, but could come back in.
Request a
and
variance.
ask for that.
Or we could also take a look at our ordinance and if things of this like this are something that we're starting to see more that are being put up temporarily and used temporarily, maybe we need to take another look at our ordinance to allow them.
Both of those options are within your wheelhouse, for sure.
Right, but what's here today is a vote to uphold the decision of the building official as our ordinances are written today,
Whether Ken acted based on the ordinances.
that he has to work with.
Yeah.
So
May I get a sense, since, I mean,
I'll-
you've heard everything
the
about.
public hearing's closed, but I'll let you speak.
Thank you. Would you entertain a variance then, if that's the route we should go?
If a variance is applied for, we entertain them all.
That wasn't quite the answer.
We approve some and we
You feel
disapprove
strongly
some.
both ways, right?
Yeah.
Well, and part of it is we only have 4 people here tonight. Normally we'd have 7.
Yeah.
So, that, I don't know how how the rest of them would feel either, but.
Well,
And then the length of it, I would look at it, if, let's say you came back with a variance, I think we'd have to continue putting it up for 2 weeks because you're going to have a family reunion, or you're going to put it up the 1st of May and take it down the end of October.
Normally we do this latter. Yeah.
Yeah.
All right, thank you. Any other discussion? Seeing none, I'll ask for a vote. The vote is to uphold the building official's decision. All in favor, say aye.
Aye.
Opposed? Motion carries. Any other old business, Ken? Seeing none, ask for motion to adjourn. Motion by Mr. McGuire, second by Mr. Arnold. All in favor, say aye. Opposed? Motion carries. We'll convene the Plan Commission meeting shortly.
Yeah. For a hot minute, then I need it back. Yeah, I'm more of a gothic. I tried doing it on the resolutions too, but that was a no. Yeah, we got some good stuff. Yeah, I know. Well, it's not on the agenda. It's old business.
Are you ready, Brandy?
Yep.
Let me find my stuff. It's here somewhere. I'd like to call to order the Thursday, February 9th, 2017 Plan Commission meeting. Roll call, please.
Arnold. Here. Hanson.
Here.
Shriver.
Here.
McGuire.
Here?
And Stonebarger, Albertson, or no, not Albertson.
Stein.
Raleigh and Stein are absent.
Thank you. First item on the agenda is the approval of the agenda. Could I get a motion in a second?
Motion?
Motion by Mr. McGuire. Second by Mr. Arnold. All in favor say aye.
Aye.
Opposed? Motion carries. Second item is the approval of the minutes from the January 5th, 2017 meeting. Motion by Mr. Arnold, second by Mr. Hanson. All in favor say aye. Opposed? Motion carries. Third item is a resolution amending Title 21 city ordinances in regard to gambling and casino establishments.
We'll get Justin. But this proposed ordinance revision to section 21-2403 would eliminate any unlawful preempted zoning restrictions on casinos and gambling. And then I'm going to turn it over to Justin Getz to explain the background of this request.
I apologize, I just had to step out for a second. I'm sorry about that, Commissioners. So, the genesis of this proposal before you came from some research done on another item for the city. There is some question as to the way that gambling establishments and liquor licenses intertwine. And in doing some research on the issue, I came to find case law from 2011 from the South Dakota Supreme Court, which established that municipalities could not regulate gambling institutions. The court in this case, this 2011 case, construed a Sioux Falls City ordinance, zoning ordinance, much like what we have here, and sided with the Department of Revenue. The Department of Revenue contended that the ordinance was invalid because it invaded the sovereign prerogative of the state. The state argued that gambling is their jurisdiction, that they have, in legal terms, preempted the city's ability to regulate in that area. And the court agreed. The court did note, however, that there are two places, and I think I note that in my memo, two places where the city effectively retains the ability, effectively, to help dictate where these gambling institutions are located. First, there is still the ability of the city to determine locations of alcohol licensees. And that, because the gambling license is effectively attached to the alcohol license, it's a certification attached to the alcohol license, that allows the city to be able to regulate placement. There is also a statute that the city council can reference whenever there is an alcohol license with a gambling certification before it. And so there are options available to regulate it. It's just that when we have in our zoning ordinances unique regulations that pinpoint gambling institutions and say either they are excluded uses or they are conditional uses, that is a regulation that invades the province of the state, according to the South Dakota Supreme Court. So that, for that reason, I suggested that those references in our zoning ordinance to gambling and casino establishments be struck.
So, we can't govern where casino and gambling establishments can be. I see we're taking them out of the conditional uses, and then they're in the accepted uses in C1, C2, C3, and the gateway overlay. What about R1? Can they go in R1 then?
See, you point out a very good point. That was initially my concern that, well, if it's free reign, that doesn't augur well for the city. But the fact remains that location is still able to be regulated on the alcohol licensing side.
Unless I want to put a casino up I'm going to just put a tanning shop and a casino. And I want to do it in the R3.
Can I talk?
Go ahead, Luke.
Okay. I didn't know if you'd open the public hearing. That was the question. Luke
I'll
Muller,
do
First
that. I'll
District.
open the public hearing.
Thank you. Same thing. One thing that I would venture a guess, and I don't know if Justin would agree or not, I would say that it's entirely likely that you would figure that a casino, based on what state law is as far as what you can and can't do in reference to that, a casino would be considered an accessory use at that point to a bar or tavern. And that's basically it. That may be something you may want to list into your ordinances, that they are considered as a accessory use to those things, but I would say that that's probably the most likely. Whereas you would not expect a casino or bar necessarily, or a casino as an accessory use to a tanning salon.
I would agree with Luke's assessment. He just put it in more zoning terms, what legally is the case, which is the gambling certification is attached to alcohol, and it wouldn't be attached to tanning or any
A
other
home
kind of use.
occupation.
That's correct.
Has this been challenged, or why is this coming up?
The reason why this is coming up, Commissioner, is literally I came across it in my research on another topic for city government. That's the only reason why I'm bringing it up. It was a 2011.
The reason I ask that is because there's a lot of court cases and things around the country where certain you name it, organization challenges something and it gets changed. The city of Watertown, I think the residents of Watertown have liked their ordinance the way it is. That's why it's in place, I assume. Nobody's challenged it. Why do we have to change it unless somebody challenges it? That's my question to you.
That's a very good question, Commissioner. My role as city attorney is to be the chief legal counsel for the city, to protect it from assertions of or potential court challenges to whatever it does, be it ordinances it passes, be it actions taken by department heads. So when there is a framework of law that has been found to be invalid on its face, I am charged with ensuring that it gets off the books if I see it. As an attorney, and that's my obligation, to make sure that state law is adhered to, the Constitution of the United States and that of South Dakota is adhered to. If indeed my interpretation is incorrect with regard to this ordinance, I wouldn't put, I would certainly say it's a possibility. But after consulting with the chief legal counsel for the Department of Revenue, he verified my analysis.
I'm going to go back in time a little bit on a personal experience. It's been several years ago, but when I was in the school system, years ago I hired a music teacher. And Watertown has always, it's a pretty traditional conservative community, and many or most all of our Christmas programs had some resemblance of the real meaning of Christmas. Okay? My new music teacher right out of college that year brought her program into me, and I read through it, and she said, this is what I want to do for our music program, for Christmas program this year. And it was a cute little program, but nothing at all about the real meaning of Christmas. And I challenged her on it a little bit, and I said, why, I would prefer that you would find one that, reflected the real meaning of Christmas a little bit more. Well, we can't do that because in Sioux Falls, there was a court case, and they were struck down, and they had to cut them out. I said, I believe the people of Watertown prefer to have a program like that, and I said, as far as I'm concerned, we'll keep doing it until somebody tells us we can't do it. And we did it for years, and probably still doing it. We're singing Christmas carols and things in school programs. So that's why I challenge you with it. Just because it came up someplace else, I don't think necessarily means that we have to change it.
And if I may,
That's just my personal opinion.
Sure.
But
And if I may, Commissioner, I, on a personal level, empathize with this viewpoint, and I can tell you that the reason why the Department of Revenue, I feel strongly about this, the reason why they challenged this, the reason why they had the court establish this in law was the very concern that you just touched on. If localities were allowed to determine where gambling establishments could be in the state of South Dakota, there'd be a lot of quote-unquote dry communities, if you will, for for gambling establishments, video lottery, scratch tickets, you name it. That's the reason why, based upon that 2011 Supreme Court case, the court basically said, this is written in the law, this was written back in the 80s for that reason. These forebears at the state level saw the writing on the walls and saw that municipalities would have issues, certain municipalities maybe more so than others. But in order to ensure that this was provided statewide, municipalities couldn't butt in and occupy the field of state regulation that they had set for themselves. It really comes down to who is the supreme law of the land. And even though my personal views may go against what is embodied in what I'm suggesting here, I'm charged with ensuring the Constitution of the United States and the state of South Dakota are upheld. And that's ultimately what I have to act on here.
Well, it was triggered a little bit by one of our conversations at one of our Tuesday morning meetings when we had a request in the Gateway District for somebody to put in a casino license, and we denied it to him and said, well, that's prohibited within our ordinance. And then part of that is when Justin then did a little more research and said, guess what? We can't say they can't have it. City Council might be able to regulate it by adoption of the liquor license, but
Up to this time,
that
when
was
somebody
part of
wants
that
to,
trigger.
up to this time, when somebody wants to put a video lottery establishment in, it always has come to the Plan Commission, and we've said, yep, it's an applicable use in the zoning ordinance, and then it goes to the City Council for the alcohol side. So we've had two boards that had different sets of eyes on the same.
And we'll
Now
still
we
be,
won't. Now they won't have to
we'll
come
still
to
be,
us for any
We'll
reason.
still be having to do the ground because we still have to ensure that within the zoning ordinance it's more than 100 yards from any church, school, state,
That's correct.
But
school thing.
that's
So
done
we still
in.
have to bless the ground before it can go to the city
So,
council.
so if a new video lottery establishment wants to come into a new location where it's not currently at, it still has to come before the Planning Commission.
That's correct. Yep. We'll still have to do our research and then bring it forward to you. You're still going to have to bless the ground before it
So
goes to
we,
the city council.
we still get to look at it.
We're still so many feet from a church and daycares.
That's correct.
That adheres closely.
That's my concern. I
Okay.
guess, is that all of a sudden one goes right next to the church downtown.
No, it would have to be associated with a bar tavern use. It would have to be. So you would be able to regulate its distance from churches, daycares.
So you can't have a video lottery in a convenience store that doesn't have a bar or tavern?
That is my understanding, yes.
All right. Anyone else speak in the public hearing? Seeing none, I'll close the public hearing, ask for a motion and a second for discussion. Motion by Mr. McGuire. Second by Mr. Hanson. I agree with Dennis. Sometimes I look and go, I don't want to change all our ordinances unless we have to, because it allows the common people of the community and multiple boards to have their eyes on something, and we're less likely to make mistakes the more people that look at it. But in this case, you're assuring us that it still will come before two boards, the Plan Commission and the City Council?
It will as a result of the fact that it is tied to an alcohol license.
Okay.
Everything that you would do with an alcohol license, you would continue to do.
Then I would recommend we make a motion to approve it with the assertion that all video lottery licenses in the city of Watertown are linked to an alcohol license. That way it comes before us.
That was what I was told by
Okay.
the Department of Revenue.
I think if it's in the motion that that it is linked to an alcohol license, so they can't fly under the radar, and that we unintentionally have one put where we don't intend it to be. So the motion would be to approve it as written, with the guarantee that they will be linked to an alcohol license or beer wine license of one sort. Do I have a motion?
I'll make that.
Motion by Mr. Arnold, second by Mr. Hanson. Any other discussion? All in favor say aye. For the record, Mr. Dolly is here. Fourth item on the agenda, I'll make sure I'm on the right spot. Fourth item on the agenda is the annexation and zoning of Rogers Outlot Number 2. I think Dennis on that now. We couldn't have accidentally missed it. That doesn't have to be a link to alcohol license.
Okay, so we'll start with the annexation and zoning of Rogers Outlot Number 2. The petitioner submitted an application and petition on January 11th, 2017, requesting approval for annexation and C3 highway commercial zoning. The adjacent zoning designation is also C3. The adjacent public right-of-ways will be included in the annexation and zoning of the property. It meets all the requirements of a C3 for a C3 minimum lot requirements. Municipal utilities will provide service to the annexed property. There's 4.1 acres involved. It is not in the floodway or floodplain and does not need park dedication since the proposed zoning is commercial. And staff recommends that the Plan Commission approve the application to annex and zone the above said property.
Thank you. With that, I'll open the public hearing. This is the property we talked about a couple weeks ago, out by the interstate in the area of McDonald's.
Yep.
See Mr. Folkerts is here. Any changes from what we talked about before? Everything is as we said before? Okay. And what we're doing right now, we're not looking at any plats or any lots or anything. All we're doing is we'll have two votes. First on the annexation into the city limits of Watertown, and second is a C3 zoning. And everything around it is already C3, correct? Little business park on one side?
Yep.
And it is adjacent to a major highway.
Yep.
Anyone have anything to speak on behalf of this in the public hearing? Seeing none, I'll close the public hearing, ask for a motion and a second for discussion.
Make a motion.
Oh, come on, I'll reopen the public hearing, come on up.
We can do that for the preliminary plan.
Oh, that's for the preliminary plan, not for the zoning and annexation. Okay, I'll leave the public hearing closed. I have a motion by Mr. McGuire. Did I have a second? Second by Mr. Dolly. Discussion. We looked at this a couple weeks ago. It looks like it's C3 highway commercial. No questions. I'll ask for a vote on the annexation. All in favor say aye.
Aye.
Opposed? Motion carries. I need a motion and a second for the zoning. Motion by Mr. Dolly, second by Mr. McGuire. Any other discussion? Zone C3 commercial. All in favor say aye.
Aye.
Opposed? Motion carries. Item number 5 is a preliminary plan for New Venture 3rd edition.
Okay, so then this is what we brought to you guys as a discussion item last meeting on January 10th. So the petitioner submitted preliminary plans on January 26th requesting approval of New Venture 3rd edition. This plan has been brought before you previously as new business during the January 19th Plan Commission meetings. Scott Calvert of Austin Engineering and Bill Folkerts made some changes to the preliminary plan. They are proposing approval of the preliminary plan that was conceptually brought to you at the previous meeting for discussion.
And we had some handouts that were, is this the updated one, or is this
Yes.
the same as what's in our packet?
Though that's the drainage, we'll address that too.
Okay.
They brought in some revised drainage plans. And then Calvert addressed concerns mentioned by the board and took into consideration their recommendations. So I'll pull up the Okay. So the facts about the preliminary plan, the adjacent zoning designation is C3 commercial, and it's going through the annexation and zoning process. It meets, the lot areas meet the regulations for a C3 district. The plan will create 6 lots, and lot 4 is the detention pond, which will be dedicated to the city. Proposed 60-foot right-of-way in conformance with adjacent developments. City standards has been 66 foot for public right-of-ways, but that's one of those things that we talked about. Since it conforms with what's existing, that's something to keep in mind. Proposing 36-foot public streets on proposed 35th Street Southeast and proposed 7th Avenue Southeast. And then proposing a 28-foot private drive on lot 6, right there. Proposed 35th Street Southeast will make the existing structure of Quality Inn and Suites non-conforming by not meeting the 40-foot front yard setback, as it will become a front, as required by zoning ordinance. To obtain building rights to lot 5, property owner would have to receive a variance from the Board of Adjustment if he would want to make improvements to that building. And sidewalks are proposed for one side of the street, which is non-conforming with ordinance 240510, stating concrete sidewalks shall be constructed along each side of every street shown on the plat. They're showing sidewalks to come along that jog there. And in front. Okay, the 100-year floodplain is not present on site. Detention pond is required to hold 2-year capacity volume for Willow Creek watershed. And the BMP development agreement for stormwater pond will be made between New Venture Inc. and the city to ensure maintenance is accounted for. So this is the plans. With that, I'll turn it over to you.
Okay, I'll clarify a couple things as well. So what I just want to briefly point out is what has changed since the previous concept that you looked at is, if you notice where the private drive goes north and south along the western edge of this plan and then turns into 7th Avenue Southeast, that became a turn instead of the previous version we brought before you had a roadway going to the west. And the developer was able to prove through his engineering team that two things were impractical about that. We were going to create a lot that originally was maybe going to be earmarked for a potential stormwater pond. They couldn't find that the stormwater pond would be feasible in that location. And so we as staff had concern over forcing them to have a non-compliant lot that wouldn't even be sellable, wouldn't fit within this C3 district. So then we revised our plan to make that a curved intersection instead of proposing a street going back to the west. I just want to make that clear why that changed, because I didn't want to create a non-conforming, unsellable lot. So we just incorporated that into the lot 1 so that he didn't lose land unnecessarily. The other thing that, go ahead.
Well, I was gonna, on the streets, did we have 60-foot wide right-of-ways at that time too?
Yes.
And one sidewalk on one side?
Yes. Well, that was what he was bringing forward. So one of the other things that changed is that on his previous version, they requested a 32-foot wide street width, and we did not deny that at the time, but what I did do is request that they review to make sure that the size of vehicles and the turning movements could be accommodated with that proposal. And what they found was that they needed to do a little bit wider street section, so we have a proposed street width of just over 37 feet wide now.
And the concession was also no parking on those streets.
Correct. But I just wanted to acknowledge that that's the work that's happened since you were last reviewing this plan. Okay?
Why are we not requiring sidewalks on both sides?
He's requesting that we vary from that. That's a decision that
Point out where the sidewalks would not be.
Well, I just brought this up for reference. This is the plan that we brought as new business. And then this is the plan we're looking at today. But where the sidewalks will be is where I pointed out there. Otherwise, there will not be sidewalks on the existing roadway.
This
is private.
Okay, so that's what he's proposing, is for sidewalk there.
So on lot 6, when that's developed, will there be sidewalks on lot 6?
Which one's lot 6?
The big one in the middle. We don't know what's going to be there. Could be a restaurant.
We don't know what's going to be there.
But I'm not comfortable saying you don't have to put sidewalks there.
Until we know what's going to be there, I don't see a purpose in trying to.
Right. I'm not saying you have to put them there now, but when it's developed, will he have to come back before us to get a waiver for those sidewalks if they choose not to put them on lot 6 at that time?
unless you incorporate it into whatever you accept right now that says it wouldn't be required. Otherwise, if you don't say specifically they're not included there, they would be required at the time of a building permit, and they would
Okay.
have to come before you then to ask for a
Okay,
variance at
so,
that time.
so as long as, once we see how that's developed and what's there, the assumption is there will be sidewalks on that. We're just talking about the sidewalks that are on the current diagram. Okay. Anything else, Brandy?
No.
Public hearing's open. I think we had somebody that wanted to speak in the public hearing.
My name is Cam Patel, and I bought from Bill like a 2015 Country and Suite, and I have on purchase agreement like a no compete. So I don't understand why he tried to build that, because we have on purchase agreement 5-year no compete on agreement.
That's nothing that this board takes into consideration. I'll defer that to Justin, and he can direct you to where he would think that would go.
Mr. Patel, the jurisdiction of this plan commission is to look at uses in the community, to look at plans, to see if they comport with our laws regarding zoning ordinance. The matter that you're discussing is a contract concern, and contractual matters are generally dealt with in circuit court. If there is an issue that you have about whether this is transgressing the contract provision or not, I would suggest obtaining counsel and pursuing your options that way. Unfortunately, here we are not able to. Well, the plan commission, it doesn't have the jurisdiction and would not be able to act upon that concern.
Thank you.
Sir.
Thank you. Is anyone else here to speak in the public hearing? Seeing none, I'll close the public hearing, ask for a motion and a second for discussion.
I'll make a motion.
Motion by Mr. McGuire,
I'll second.
second by Mr. Arnold. Any other discussions other than, we just want to make it clear that we didn't waive the sidewalks in Lot 6.
Okay, so one other item that I want to point out on the resolution that you're about to take action on is we did request some additional stormwater calculations and related items from the developer and his engineer, and we just got that this morning. So we specifically worded the resolution that the plan, or that the resolution allow us for time to review that and make sure that that work is perfected before plating happens. So we did.
So I'll have the motion, I'll ask if the motion can be amended to.
No, that's the way we wrote the resolution, to allow that.
So it's already included in the resolution that the stormwater will
So
be
there's a
approved by you guys.
contingency in the resolution that says that stuff has to be perfected before plating can happen.
Okay, sounds good. That way we're not getting in the way of the construction or the development. Any other discussion? Seeing none, I'll ask for a vote. All in favor, say aye.
Aye.
Opposed? Motion carries. Item number 6 is the plat of the East Park Second Edition.
You don't need me anymore, right? I don't have a canopy on either.
And also in that resolution, we'll include we'll look at the sidewalks upon building permits.
Right. We didn't in any way waive the sidewalk requirement on Lot 6.
Okay, so for the plat of East Park Second Edition, petitioners submitted plat and plat certificates on January 11th, requesting approval of East Park Second Edition. The preliminary plan of East Park Edition was approved by Resolution 2015-19 with conditions on June 18th, 2015. So this is the plat that they're proposing. Okay, so I guess we can just go right into the conditions that our concerns are, or that Shane will touch on.
Now, can you back out on this one a little bit and show us exactly where it is in that Willow Creek in comparison to the Willow Creek? Is this the Morris property?
No,
This is Coho.
Coho, formerly Little's Addition.
Okay.
I can pull it up on the GIS.
So the preliminary plan for this development was approved in 2015. It was something that this board took action on sometime, I think, in May or June of 2015. And so this is the ultimately, the plat that's coming forward out of the resolution that was signed. In fact, the resolution that is related to this plat is the 18th of June 2015. So with that, I guess I do want to make reference to that resolution that you passed on June 18th of 2015. It had several points, 11 in fact, that were tied to that approval of the preliminary plan, and there are a few items that have changed since that resolution. One is the developer and city staff are working together to create a regional pond that would take care of the water quality and the 2-year stormwater retention and management. And so that essentially is not a part of this plat any longer. However, it's up to staff to make sure that this city's stormwater provisions are accounted for. And so we're working for a new location for the storm pond. It's not going to be contained within the platted area that you're looking at today, but it's going to be a better end result for the city and the community where this stormwater pond will end up. So I can ask more or answer more specific questions if you have them.
You've talked about that before. You and I have talked about that before. Wouldn't it be nice that if each small area didn't have to retain their own water, if there was more of a regional area and they all contributed to that area, and that's what you're working with them on? And you're comfortable with that? All lots compliant, Brandy, as far as size, setback, width, length?
Yep, and then they revised their easements to meet utility standards.
Okay.
The access points were another concern that were addressed on the resolution. And we made sure to account for that in the certificates, that they would be allowed 2 driveways per block face, with the block face defined as no less than 300 feet or 330 feet. Just because in their preliminary plan, what they showed that got approved, that was there was more driveways than you guys were willing to, or the board at that time was willing to accept.
Okay. And they've met those conditions that we required?
Yeah, they signed. That'll be in the certificates.
Okay.
We approve the final number and location of the driveways upon building permit application, but your resolution defined how many driveways there should be. So
All right.
we're conforming with that.
Thank you. With that, I'll close. Does anyone else speak in the public hearing? Seeing none, I'll close the public hearing. Ask for a motion and a second on resolution 2017-08.
I'll move.
Dennis? Second by Mr. Hanson. Any other discussion on it? All in favor say aye. Opposed? Motion carries. Item number 7, old business A, Stony Point 3rd edition discussion.
Okay. So we received a plat of Stony Point 3rd edition, and So we held a design review team meeting on February 2nd. And we also received a plat of Stony Point 3rd Edition in July 2016, where we sent the developer and property owner a letter addressing our concerns with that plat. And we can compare the two later in the discussion. But basically, our design review team takeaways was that we'd like to prove that the easement road can support 75,000 pounds for fire code. And if they were to rescind their current preliminary plan of Stony Point that was approved with conditions, and then potentially resubmit a new preliminary plan of Stony Point.
Now, we approved a preliminary plan, but the city council did not, correct?
Right, and that's all, Plan Commission only has to for preliminary plans.
Well, actually, the council does approve the plats that are a resultant out of the preliminary plan, and that was voted down at the previous council meeting. So what, where I'm at with this, or the reason I brought this up for discussion is what we're receiving from the developer are smaller portions of the preliminary plan, but don't address all of the issues and don't have full compliance with the preliminary plan that was passed by this board. And so what I'm struggling with and trying to get direction from, so I give the developer and his engineering staff some type of feel for where or what we think can happen. I'll just give you, for instance, and we'll toggle back and forth. So this is the current plan. Oh, okay. So this is a variation of the preliminary plan, and all it really essentially does is wants to define 3 more residential lots. Issues with it, it doesn't designate any more public right-of-way, which would comply with the preliminary plan. This is now called a access and utility easement, as well as this area is here. So fundamentally, we have some concerns with that and are not recommending this version of the preliminary plan. Can you go to the previous one that we had?
Yep.
So earlier this year, this was the version we got, and our response was that it still didn't conform completely with the preliminary plan. And essentially what's different is it's only a portion of the preliminary plan, and it doesn't account for that second roadway out that we had discussed and things like that. And where we're at as a staff is we recognize all the effort that was done in the previous planning commission meetings and all of that did direct it to get to that more full-blown, complete development of the whole area. And now what the developer's indicating to us is that he no longer wishes to develop the whole entirety of the area. He just wants to get a few more lots on the top. This, in our current version that we have to consider, this block 2 is now an outlot that encompasses the whole lower half of that. And what's still frustrating for me as a director of the staff, and we seem to have pigeonholed the whole area into one concept. And my response to the developer is getting more difficult because we're just automatically categorically saying no each time we receive something. And I think what I want you guys to weigh in on is ultimately some